Good afternoon, everyone. My name is Carney Simpson. I'm the symposium editor for the Washington and Lee Law Review. I want to thank everyone for coming this afternoon for our symposium celebrating the landmark Supreme Court decision of Gideon v. Wainwright. I also want to welcome all of our participants and moderators who traveled to be here today. I'm glad you all made it safely. Next, I'm going to introduce a man who came to Alex and I last spring and proposed to us that we should host a symposium that celebrated the 50th anniversary of Gideon. And not only did he bring us this idea, but he also is the reason why we have such a great lineup of speakers for the next 2 days that will be here. That man is Washington and Lee's own Associate Clinical Professor of the Criminal Justice Clinic, Professor J.D. King.
Thanks, Carney, and I'll be brief. Thank you all for coming. I know several of you had to deal with weather delays and fog delays out of San Diego and snow delays or rain or something out of the Northeast. But thanks for coming, and I especially first want to thank Carney and Alex Shugsta and the rest of the staff writers and people on the Law Review for working so hard up till now and what they're going to be doing going forward, helping everyone get their submissions into publishable form, as well as driving people from the airport and to the hotels and assembling those wonderful gift baskets for those of you who already checked into the hotel. I also want to thank Wendy Rice, the administrative assistant for the Francis Lewis Law Center, the main sponsor of this event, and Lisa Gerhardt, who is the administrative assistant for the Law Review, for all the work they've done. And in terms of funding and making this possible, the Francis Lewis Law Center, the Dean's Office and the Provost's Office here at Washington and Lee, and the National Association of Criminal Defense Lawyers, a few representatives of whom I just saw walk in, who are here and who have also contributed funding and ideas to make this symposium happen and a success. Like many of you, I spent a couple of nights ago, Tuesday night and into Wednesday morning, watching the TV, and in my case, also the computer and the iPad and occasionally my phone, obsessively checking what was happening. And I was watching it with my kids, for whom it was the first election they're really conscious of, 10, 7, and 2. And when it began, when the first exit returns came in, they were all very jazzed about this election. They would come running in and they'd say, "Dad, they just announced Vermont, and Obama won." And they'd go running back to the TV room, come back a few minutes later, "Dad, they announced South Carolina, and guess what? Romney won. Now he's up 7-3. And after a while I said to them, really, we only care about 7 states. and their faces sort of fell because then I had to follow it up. None of the 7 states we care about are going to report until long after you guys are asleep. But it was a difficult thing to explain to a 10-year-old and a 7-year-old. Truthfully, the 2-year-old didn't care. How certain of these states were essentially invisible to us because they were not contested. And it got me thinking that what is not contested tends to become invisible. And I think one of the real pleasures of my life over the last couple of weeks, when I haven't been obsessively watching TV and checking the internet on the election, is reading the papers that you all have submitted to this, and how one of the common themes is making visible what had previously been invisible or taken for granted. And so it has been a great joy for me to read these things. The ideas, the approaches, the viewpoints, the proposals that are in all of these papers and that you're going to hear tonight and tomorrow are diverse, often conflicting, and always provocative, and I think we're in for a real treat. And even before the live part of the symposium, I feel just honored and lucky to have been able to engage with these ideas, and I've learned a lot. Some of the things I've learned from Jenny Roberts' article, fewer than 0.5% of people charged with misdemeanors go to trial in New York City. I was astounded to hear that among all the sort of statistics you'll hear. From Robin Steinberg's article, Bronx defenders, only been in existence 15 years. Last year they represented 30,000 clients, and now they're doing outreach in California, Texas, and Nevada with the tribal defender of the Salish and Kootenai tribes in Montana. It's amazing. I also learned from her article that the Bronx Defender folks, even after all of that, still get sensitive when someone calls them a plea lawyer. For those of you who have read the article. And I learned from Ron Wright and Ralph Peoples that the many hours that I spent reading Moneyball and watching the movie and trying to apply those principles to my fantasy football team unsuccessfully might not actually have been wasted time after all. So when you assemble a group like this, and I counted before coming in, there's 16 either current or former trial lawyers who are going to talk tonight and tomorrow. It's not really a recipe for broad consensus, in my experience, and I think that's a good thing. I think it is a recipe for dynamic exchange of ideas, disagreements, and discussions. So briefly, as I read them, I think the papers, certain themes emerged that we're going to hear about a lot over the course of this evening and tomorrow. One is the idea that we live in a world of limited resources. And we live in a world of not only limited financial resources, but limited political will. And how can we work toward reform of the legal system, the criminal justice system, within the intractable constraints that I think nobody sees changing anytime soon in terms of financial and political resources. Related to that, the idea of triage that has come up time and time again in not only these papers, but in the literature on this issue. Is triage a dirty word, or is it an acknowledgement of the reality? Many of the papers address, can we employ social science methods, scientific validation, and creative incentive structures to improve the delivery of defense services and the administration of criminal justice generally. Very interesting stuff there. And in a more theoretical way, has Gideon failed to the extent we think it's failed because it has been stretched too thin, or were there conceptual flaws from the beginning in Gideon? And finally, and perhaps most fundamentally, is the way forward to simply continue demanding increases in funding for indigent defense representation, or perhaps to rethink some of the basic aspects of how we protect criminal defendants and run the criminal defense system. Like I said, these are not areas where we're going to have broad agreement and consensus, but I think we will have lively discussion. So I look forward to that discussion, the questions, the disagreements, the good company over the next couple of days. And thank you all for coming. And I turn it over to Professor Erik Luna for the first panel. Thank you.
Thank you very much, J.D. I, like others, we're very thankful for all the efforts that were put in by the Law Review, by Professor King, to put together such an outstanding group of presenters. I'd like to begin by just reading an important quote, actually a quote prior to, an excerpt from a case prior to Gideon. A case called Griffin versus Illinois. 1956. The court said there can be no equal justice where the kind of trial a man gets depends on the amount of money he has. A few years later, in 1963, the Supreme Court finally gave it its full meaning based on the Sixth Amendment right to counsel. Noted, lawyers are not necessities. They are necessities, not luxuries. In our adversarial system of criminal justice, any person haled into court who is too poor to pay for his own attorney cannot be assured of a fair trial unless counsel is provided him. This seems to us to be an obvious truth. Governments, both state and federal, quite properly spend vast sums of money to establish machinery to try defendants accused of crime. Lawyers to prosecute are everywhere deemed essential to protect the people's interest in the orderly society. Similarly, there are few defendants charged with crime, few indeed, who fail to hire the best lawyers they can get to prepare and present their defenses. The government hires lawyers to prosecute, and defendants who have the money to hire lawyers to defend are the strongest indications of the widespread belief that lawyers in criminal courts are necessities, not luxuries. From the very beginning, our state and national constitutions and laws have laid great emphasis on procedural and substantive safeguards designed to assure fair trials before impartial tribunals in which every defendant stands equal before the law. This noble ideal cannot be realized if the poor man charged with crime has to face his accusers without a lawyer to assist him. Half-century later, there are American jurisdictions where an impoverished defendant receives the facade of legal representation, which at best meets the letter of the Sixth Amendment, but certainly not its spirit, and at worst fails to maintain even a pretense of constitutional compliance. The presenters here today on this panel, Gideon, Strickland, and the right to effective representation, bring a broad basis in examining the issues presented by Gideon, but also subsequent cases that tried to give it some meaning. Professors Garrett, Drips, Alper, and Steinberg provide a wealth of experience as academics, as researchers, and as practitioners. And so I'd like to begin by introducing Professor Garrett. He attended Columbia Law School, where he was an articles editor at the Columbia Law Review and a Kent Scholar. After graduating, he clerked for the Second Circuit with Judge Pierre Laval. He then worked as an associate in Neufeld, Scheck, and Brewston in New York City. I suspect the first two are maybe well known. Professor Garrett's research and teaching interests include criminal procedure, wrongful convictions, habeas corpus, corporate crime, civil rights, civil procedure, and constitutional law. His recent research included studies of DNA exonerations and organizational prosecution. And his recent book, published by Harvard University Press, Convicting the Innocent, Where Criminal Prosecutions Go Wrong, examined the cases of the first 250 people to be exonerated by DNA testing. I should note that book was cited in a dissent by Justice Sotomayor in New Hampshire versus Perry, the case on eyewitness identifications recently decided by the Supreme Court. It is a pleasure for us to have today with us Professor Brandon Garrett. Please welcome Professor Garrett.
Thank you, JD, and thank you, Erik. And I was expecting us all to get introduced at once, but so it's an honor to be introduced separately. And but it's a fantastic panel, and I'd like to keep my remarks on the short side, maybe more like 10 minutes, so we have more time to all talk and all ask questions. Well, since Erik mentioned eyewitness identifications, buried in this draft that I have here is a mention of a case that I talk about in the book I wrote about what happened to the first 250 people exonerated by DNA. His lawyer, it's a Montana case, a man named Jimmy Bromgard, his lawyer was known in town as Jailhouse John Adams because his clients invariably went to jail. And it was well known that he would be at the bar or playing cards with his friends when things were happening in court. And it was a court-appointed county-by-county system in Montana, no state public defender system, no local public defender system in this county. And Bromgard got sentenced to 15 years. He got sentenced to life. He served 15 years before DNA exonerated him. And what's interesting about that case from our perspective on Gideon is that locally it was well known that this lawyer was a joke. His Jailhouse John Adams. Everyone knew that he was a joke. Everyone knew that it was a disaster to get this lawyer. There were only a couple others in the pool that one could get appointed. So there weren't too many choices if you were indigent in this part of Montana. But there was no way to bring up the issue, right, if he is your lawyer. No one stepped in when the lawyer filed no motions to suppress any of the evidence in the case. It was a case, the main pattern that you see when you look at trials where there are eyewitnesses is that the eyewitnesses are invariably confident of their identification by the time it gets to a trial. And so it can be hard for a defense lawyer to do much with a confident eyewitness who is wrong. Right? If bad lineups led to the person making a mistake, their confidence could be cemented by the time of trial. Well, this was the case, the rare case where the victim of this rape was absolutely unsure that Bromgard was the person. It was the weakest ID that he could imagine, where even by the time of trial, the victim wasn't sure. No motion to suppress filed. And it was a case where there were totally made-up forensics. The forensic analyst later sort of became a national scandal. No questions asked about the forensics, no motion to suppress. He got his client's name wrong at trial, which was kind of embarrassing. not the hardest name to pronounce, Jimmy, and filed no appeal in the case. And so the first time, with no appeal having been filed, the first time that the issue of the effectiveness of his lawyer came up, since he didn't raise it, there are actually a couple of exonerees whose trials I studied who actually tried to ask the judge for a different lawyer, some succeeded. It comes up for the first time on habeas. That's the first time that the issue of this lawyer's total failure to do anything in the case came up. And he lost. The courts described there being no prejudice, there were powerful forensics, there was an eyewitness who identified a shaky eyewitness, but there was plenty of evidence in the case, no prejudice. Every effort to challenge this lawyer's representation failed. Interestingly, years later, when he was exonerated by DNA, he filed a civil suit, bringing Strickland claims affirmatively to seek civil damages for his wrongful conviction. And that helped to spark the creation of a public defender system in Montana, although the suit got dismissed by the Ninth Circuit. Anyway, that's an anecdotal introduction. What my paper is about is habeas and social science, two things that really don't belong together. Habeas, in some ways, is kind of an accuracy-free zone, a black hole. But what I say a little bit about is how, most of the things that we think about as being ways that Strickland, the Strickland right and its development, Gideon is worked out on the ground, often through habeas. And in return, the Sixth Amendment and Gideon and then Strickland have transformed habeas in some pretty strange and unexpected ways. State habeas was really called into existence in a way that it didn't exist before, precisely because Strickland claims are the types of claims that typically would not get raised on appeal if you even had a state that allows it to be raised on appeal, since it involves stuff outside the trial record. And so then all of a sudden, those claims need to be exhausted in state court before you file a federal habeas petition. Well, all of a sudden, we need to have some process to exhaust those claims in state court. And so then the post-conviction process becomes that much more complicated. States have to provide these post-conviction procedures. And then lo and behold, Strickland claims become the bread and butter of habeas, the claims that are most frequently brought. And in the rare cases where habeas petitions are actually granted, it's typically a Strickland claim that's granted. Strickland becomes sort of the umbrella for judges to talk about a trial that seems bad. The second most common claims tend to be Brady claims. So all of habeas is about, one way or the other, blaming the lawyers for what happened at a trial, but it's really an umbrella for talking about the evidence at the trial. And so if it was a case where there was a terrible eyewitness, one talks about the possibly wrong eyewitness through the lens of, well, should the lawyer have done more to attack that terrible eyewitness? Or if the forensics were totally flawed, the regulation of the introduction of that evidence would be a matter of state law. Well, it becomes federalized through Strickland, through the ability to say something about why the lawyer utterly failed to say something about those forensics. And that said, even if Strickland and the subsequent decisions that sort of came about at a time when the court was also trying to limit habeas at the same time it was expanding it by tightening prejudice requirements across the board, what Strickland is an umbrella for is still hard to say, because when judges decide, is this the really bad case that will actually merit a dismissal, or if lawyers are thinking about, will our missteps result in something serious happening to this case down the road, there still has to be some metric for deciding, well, what are the really bad cases that the Sixth Amendment is going to mean something for? And there, all we have is the vague language about the wide range of professional competence and then this prejudice requirement, which means something like there's a reasonable chance that this affected the outcome at trial, but there aren't particular guideposts for what prejudice means. And what judges say about prejudice is wildly varying. It does seem to involve some sort of a seat-of-the-pants judgment by judges years and years later based on a cold record that, oh, wait a minute, this is the unusual, really terrible case where something serious happened. And so people have noted over the years that, maybe this kind of thinking about trials through the lens of attorney performance, but really talking about, was there something flawed about the outcome at that trial? Maybe it could be linked to something more valid, something grounded in some research about what actually impacts juries. And there, social scientists have spent a fair amount of time carefully studying at least some types of evidence and thinking about how lay people react to evidence. And they've generated some really useful information, but one thing that they don't usually do is study lawyers and the conduct of lawyers and how the strategies of lawyers actually impact trials. You know, social scientists are sort of lawyer-phobic, judges are social science-phobic, and so there's potentially a gap there that could be narrowed a little bit if maybe social scientists realized how important it is for judges to have more information about what actually impacts jurors in terms of attorney performance. So that there might be room to do a little bit more there. And just to provide one example, there's some work being done now on fingerprint evidence, which suggests that what's really powerful to lay people isn't just what does the fingerprint expert tell the jury in terms of, no one in the world could possibly match this fingerprint. It's absolutely unique to the exclusion of all other people with markings on their fingertips, which is all of us. No one else could have made that print. And so some judges had suggested that, well, maybe a competent defense lawyer would say something to cross-examine that fingerprint examiner. But when a fingerprint examiner can say something that ambitious, what's the defense lawyer supposed to do? If they got their own expert would agree because fingerprints are unique after all. There's really no role for the attorney in that situation where the evidence is simply so that powerful. Well, it turns out that there's more evidence that, well, there is an error rate to fingerprinting. Fingerprinting is not an error-free process. It's based on the experience of the examiner. And it also turns out that if lay people hear something about there being a possibility of error, even if we don't know exactly what the error rate is, that really impacts them. Because we all thought that, fingerprints are, they're like DNA. There's an amazing amount of information on those fingertips. There couldn't possibly be errors, and it really counters a layperson's priors to actually hear, oh, wait a minute, mistakes can be made. And so that's an example of some social science research, which actually may suggest something useful for defense lawyers to do. And it might suggest that down the road, if a lawyer failed to do any cross on error rate, maybe if it's a case that relied on a fingerprint, a judge would say, look, there is prejudice. Would a judge actually say that? Probably not, because it's so rare to actually get relief post-conviction. But it's the kind of thing where maybe there could be more work done to find areas like that, where there might be surprising things that lawyers could do, and surprising things that judges hadn't been focusing on that they could focus on. Anyway, I'm sure we'll be talking a lot about the triage point that Erik brought up. And there's then the question of whether thinking about social science research and what lay people think could help to inform triage, at least for cases that you think are going to a trial. Whether there could be some prioritizing done based on that type of research. Anyway, I'll stop there and look forward to talking more after we all make our initial presentations.
Thank you very much, Brandon. Our next presenter is Professor Donald Dripps of the University of San Diego. Professor Dripps is a graduate of the University of Michigan Law School, where he was the editor-in-chief of the Law Review and a member of the Order of the Croix. After receiving his law degree, he worked as a law clerk for Judge Amari Curtis of the Second Circuit. He has amassed an amazing amount of scholarship cited throughout the literature. Recognized scholar of criminal procedure, evidence, and criminal law. He also teaches administrative law. He has been a professor at the University of Illinois, visiting professor at Duke, a visiting professor at Cornell, as well as the James Annenberg Levy Professor of Criminal Procedure at the University of Minnesota before coming to the University of San Diego. He's also the author of one of the legendary case books in the field, Criminal Law and Procedure by Perkins and Boyce. Please help me welcome Professor Donald Dripps.
Thank you, Erik, and thanks to JD and Carney and Alex and all the folks here for organizing a truly great event. We all know that Gideon failed to provide effective indigent defense. Most urban defense systems are overwhelmed by caseloads that preclude effective assistance for all clients. The paper compares two leading explanations for why Gideon failed. The first of these is a liberal narrative, and the second is a political economy narrative that I would label neoconservative, but for the unsavory reputation that lingers still over that label. So the liberal narrative celebrates the Warren Court's iconic decisions, Gideon especially, and the liberal account explains legislative neglect of indigent defense as symptomatic of political incentives, since suspects and defendants are overwhelmingly young and disproportionately black and overwhelmingly male, and potential victims include both this demographic section and almost all others. Rational politicians are more concerned with public security than with individual liberty, racial even-handedness, or procedural fairness. The imbalance is exacerbated by the political influence of the law enforcement bureaucracy, which reinforces the broad victim interest group with a concentrated interest on behalf of policies that make life better for prosecutors, police officers, and correctional personnel. Now, the liberal narrative laments Strickland as a failure of nerve by the Supreme Court and looks to some new majority of justices to adopt one or another reformulation of effective assistance doctrine that would force legislatures to provide the resources to restore something resembling an adversary system. The political economy narrative, by contrast, accepts the liberal version of process theory, but sees the political process as dynamic. We can expect other actors, in asking how we can expect other actors in the system to react to judicial intervention, the political economy approach sees the Warren Court revolution as futile and perhaps perverse. By constitutionalizing procedure without constitutionalizing substance or the plea bargaining process, the Warren Court gave legislatures and prosecutors both the power and strong incentives to increase sentencing severity and nullify procedural rights by functionally coercive plea officers. This laid the foundations for the punitive turn in criminal justice policy, and by the punitive turn, I mean the decision in 1984 and thereafter to double the national prison population per capita to give us what is now the largest prison population per capita of any society that has records and doesn't have a camp system. It's given us a system that has put more young black men in prison, in jail, waiting trial, or on probation and under the supervision of the system. In many states, that number is higher than the number of young black men in institutions of higher education. That's the punitive term. Now, the punitive term was made. The punitive term made the Warren Court landmarks irrelevant. Everybody waives. Everybody pleads out, because if you don't, the trial penalty is catastrophic. And the emerging research indicates that rational defendants who are innocent are pleading out. And Bill Stuntz, Professor Stuntz, the late Professor Stuntz, revered, and for my part, went further and attributed the punitive term, at least in part, to a backlash against the Warren Court criminal procedure decisions. Now, in this paper, I argue that both of the leading narratives are correct about Gideon. And I defend this claim by presenting two thought experiments. In the first experiment, we test the liberal narrative by asking what the criminal justice system would look like after the punitive term if legislatures provide, or were somehow forced to provide, adequate defense representation for indigent defendants. We don't need to speculate. In the federal system, the defense function is in much better shape than most state-level urban systems, in large part simply because of greater financial support for which the late Chief Justice Rehnquist deserves a considerable share of the credit. I think it's fair to say that federal indigent defense is about as good as we can expect the Supreme Court to ever force upon the states. What is the result? What is the result? In the federal system, 97% of convictions result from guilty pleas, an even higher rate than the astounding 94% in the states. The average sentence is 46 months, and the median sentence is 24 months. Despite three strikes laws, the sentences available in a federal prosecution, says Professor Sarah Beal, are generally higher than those available in state court, often 10 or even 20 times higher. Is that not the very model of a criminal law that is too broad, too severe, and practically dominated by the opaque and unaccountable discretion of executive agents? Bill Stuntz thought it was. Rachel Barco, in an important recent paper, agrees. She says, in a government whose hallmark is supposed to be the separation of powers, federal prosecutors are a glaring and dangerous exception. Now, if we learned anything from Stuntz, and we've learned much, it should be that we must think about the criminal justice system as a system. For liberals, this means that even radical reinforcement of ineffective assistance doctrine standing alone would be futile or perverse. Better prepared defense counsel would still be advising defendants to plead for whatever reduction in liability the prosecutor deigned to provide, and this advice would still be given to defendants who colorably claim factual innocence. Now, consider the second thought experiment, in which prosecutorial discretion and sentencing severity are curtailed by reforms such as those proposed by Stuntz. He said, well, let's have less severe sentencing discretion, let's have one-way judicial discretion to ratchet penalties down, to depart downward, to have disparity review across the state to show that the sentence in the instant case was not eccentrically high. He wanted judicial review of plea bargains that was more searching and less tied to the bargains themselves, as operates, as he said, in the military system. And he argued also for reading normative content, vague normative standards about wrongdoing into the substantive criminal law. He also proposed strengthening indigent defense, but for purposes of my experiment, I want to assume that that didn't happen and everything else did. So standing alone, suppose we somehow managed to return the frequency of felony trials from one case in 20 to one case in 5, and didn't reinforce indigent defense. The arithmetic is brutal. If you go from 5% trial to 20% trial, you need to quadruple the resources available to indigent defense in order to do the trial work. And the system right now is way below par. So that if we're talking about providing truly adequate representation for a system that tries 20% of the cases, we are talking about more than quadrupling the resources devoted to indigent defense. I agree. Right? I agree that as a normative matter, that priority, that resource commitment, ought to be thought of as entailed by the decision to use the criminal justice system at all. If you're going to spend billions on prisons, then spending tens of millions on the checks that are necessary to keep that prison system within the bounds of a liberal society, that seems to me a perfectly defensible normative judgment. The important point I would say here is that reforming indigent defense by itself is not going to succeed in improving the system. And other changes in the system aren't going to be worth much unless there's a dramatic increase in the level of support for indigent defense. Now, systemic reform is not, I think, beyond us. The retreat from Gideon followed the Supreme Court decisions affirming the foundation of the punitive term. Two decisions in particular, Borden and Kircher against Hayes and Rommel against Estel, both one in the early 1970s, one in the early 1980s. Both of those decisions were 5-4 decisions. They could have gone the other way. And if they had gone the other way, some, perhaps much, of the pointless pain we have witnessed over the last 30 years might have been avoided. The Court's recent decisions in LaFleur, Frye, and Padilla suggest that even the current Court is willing to flirt with radical reform. The tone of Justice Scalia's dissent in LaFleur is, my colleagues are getting ready to regulate plea bargaining. They're getting ready to regulate prosecutorial discretion in the plea process, as if that were not a consummation devoutly to be wished. If the Supreme Court took the next logical step in that line of cases and told trial judges they could not accept a plea unless at the colloquy defense counsel reported a factual investigation, a review of the available defenses, and a decision to either interview or not interview an identified list of potential witnesses, that would bring the system into a state of crisis. At that point, the resources called upon just to process a guilty plea would be beyond the assets of the current system, and legislatures would be forced to choose between the current system of universal plea bargaining, if you will, and letting people go. They would either have to ratchet up the level of indigent defense to the point where people got competent advice before pleading out, or they'd have to have a much smaller criminal justice system. And that is something that the Court might very well do. It would be radical, but it's not beyond the realm of political vision. So liberals have no cause to despair over the prospects for a second criminal procedure revolution. In the paper, I talk also about what conservatives might be thinking about doing. And there are lots of principled conservatives who actually see 2 million people behind bars as big government, and that's a problem. Right? And some of them may surprise you. So Edwin Meese leads a right-wing smart-on-crime movement. Virginia's Senator Jim Webb is a Democrat, but you wouldn't call him a liberal, I don't think. He's leading a movement to have another national commission on crime and justice, a procedure that would give us the ability to look systemically at everything that's going on in the system and try to find a way to decarcerate without unacceptable consequences. There are some signs, right? Some signs that even conservatives might be in a position to proceed to address these interrelated systemic problems, including indigent defense support. Now, that said, all right, what's the difference between the liberals and the conservatives? The conservatives want to achieve decarceration and a vigorous defense function through the legislative process, and liberals say we're never going to get there because of these legislative incentives and we have to go to the justices. And at the end of the paper I say these projects are not inconsistent with each other. The truth is that the Supreme Court's successful interventions have always been either parallel to or have successfully prompted changes in popular political opinion that reinforce the decision the court made. And so Brown against the Board of Education, there was a national consensus against Southern segregation. The court moved on the Southern exception, and the country followed with the adoption of the '64 Civil Rights Act. So too with gender relations, where the court was behind the country and recognized an equal protection right for women just in time to head off the adoption of the Equal Rights Amendment. And with respect to the equal rights of gays and lesbians, by the time the Supreme Court overruled Bowers against Hardwick, Georgia had already repealed its sodomy statute, and the Texas statute was a bizarre outlier. And what happened after is the country got on board with the court and went further in a trend that had already started, and repealed Don't Ask, Don't Tell, and just this last Tuesday, 3 more states legalized gay marriage. In the 1960s, the court led on criminal justice, and the country did not follow. The Warren Court criminal procedure decisions have never gotten anything from the public but backlash. But that may be changing. Now, what happened just this last Tuesday? What happened just this Tuesday? In the home state of California, the people overrode the legislature and reformed the 3 strikes law and said that the third crime had to be a crime of violence. And 2 states, Colorado and Washington, legalized recreational quantity possession of marijuana. Now, one swallow doesn't make a spring, but if you got enough swallows, you would have a spring. And so I don't think that we should disparage attempts by principled conservatives to get legislative progress on criminal justice. I think it's possible, and I think that progress on the legislative front and progress on the judicial front, as the experience with race, with gender, and with sexual orientation suggests, those often are causally interrelated in complex ways, and that progress on one front tends to get you a little more progress on the other front. Now, the legislative will for reform may be lacking, and for pragmatists who think that's the most likely outcome, then I go back to a paper I presented at Texas Tech earlier in the year and suggest some pretty strong things we could do to ration deliberately indigent defense. We could eliminate the right to appointed counsel in felony cases where there's no carceral sentence. We could eliminate the obligation of appellate defenders to prosecute every appeal or file an Andrews brief. We could have lay advocates. We could set up programs that train essentially paralegals to undertake the defense function. And as I understand the holistic defense movement, a lot of that is just this substitution of personnel, that jobs that don't have to be done by a high-priced practicing licensed attorney can be done effectively and cheaply by somebody else. Those jobs ought to be done by somebody else effectively and cheaply. So I have a prescription then for liberals, a prescription then for conservatives, a prescription for pragmatists. If you think that progress is out of reach, I would just remind you what the world looked like 50 years before Gideon. 50 years before Gideon, the Supreme Court reversed its first felony conviction coming out of the state system, a case called Moore against Dempsey, which dealt with convictions rendered following the Elaine County race riots of 1919. And in those cases, the appeals were heard from capitally condemned defendants who had confessed under torture and were convicted by judges and juries who were operating under the immediate physical domination of a racist mob. 50 years after insisting on minimal due process, the court in Gideon insists on a right to counsel in all felony cases. So who knows what the 51st year is going to bring? You don't know when the wall is going to come down if you butt your head against it one more time. But it's happened in the past, and it might happen again.
Thank you, John. Our next speaker is Professor Ty Alper of the University of California at Berkeley, Willis Hall. Professor Alper is a graduate of New York University Law School, where he's a senior articles editor for the NYU Law Review. After graduating, he clerked for Chief Judge Harry T. Edwards of the U.S. Court of Appeals for the D.C. Circuit. And then he joined, as a staff attorney, the Southern Center for Human Rights in Atlanta. While serving there, he worked on representing Alabama and Georgia death row inmates in all stages of state and federal post-conviction proceedings. He also represented hundreds of Alabama prisoners in federal class action litigation concerning unconstitutional conditions of confinement. In 2008, his research into state animal euthanasia statutes and lethal injection protocols received national media attention and was cited by Justice John Paul Stevens in his concurrence in Bays versus Reeves. It is my pleasure to introduce Professor Ty Alper.
Thanks, Erik. Katie. I'm going to talk about the right to counsel in post-conviction proceedings and to some extent build on the conversation that Brandon started. What I want to talk about is what does it mean to be entitled to the effective assistance of counsel under the Sixth Amendment, under Gideon, if there's no procedural mechanism to vindicate that right in the vast majority of individual cases. So we can try to change indigent defense policy across the board for indigent defendants or classes of indigent defendants through class action litigation, through legislation, policy advocacy, or rulemaking in some cases. But in the average run-of-the-mill case, where you were provided with a lawyer who didn't do his or her job, who was drunk throughout the trial, who didn't investigate the case at all, who never came to see you in the jail and tell you you had a right to testify at the jailhouse, John Adams. When you're appointed a lawyer but you don't have one who does his or her job, what's your recourse? What does it mean to be guaranteed the effective assistance of counsel? This principle that the Supreme Court as recently as last term in a case called Martinez versus Ryan called a bedrock principle that's foundational to our adversary system. What does it mean to have that guarantee but no means to vindicate it? And let me explain what I mean when I say there's no way to vindicate it. And this is where I touch on some of what Brandon was talking about. So defendants who have been denied the effective assistance of counsel can raise an ineffective assistance of counsel claim under Strickland if you can show that your lawyers performed below the reasonable standard of care and that but for that deficient representation, there's a reasonable likelihood that the result of the trial would have been different. You're entitled to a new trial. The problem is, as Brandon mentioned, these kinds of claims, these Strickland claims, almost always involve the investigation and presentation of evidence that's outside the record, extra record evidence. Evidence or testimony, for example, that you say your lawyer should have presented in the case. And in most cases, for that reason, in most states, those kind of claims can't be raised until post-conviction proceedings. The lawyer who's ineffective can't raise it him or herself. And there's often no mechanism for introducing new evidence until you get to post-conviction. And that's a problem because under current law, you're only entitled to a lawyer under the Constitution through your first direct appeal as of right. And that's what the Supreme Court said in Douglas versus California, decided the same day as Gideon. So you've got this bedrock foundational right to counsel, not only to counsel, but to the effective assistance of counsel. But you aren't allowed to raise a claim that you were denied that right until after the point in which you're entitled to a lawyer that could help you bring that claim. Now, the vast majority of defendants convicted of non-capital crimes are not appointed a lawyer to represent them in state post-conviction proceedings. And not to get too into the weeds here, although to some extent whenever you're talking about post-conviction law, you're in the weeds. But if you don't exhaust your claims, actually Brandon mentioned this, if you don't exhaust your claims in state court, you can't raise them in federal court either. So it becomes something of a classic right without a remedy for most non-capital defendants. So I want to frame what I'm going to talk about by talking briefly about two cases from last term of the Supreme Court, Maples and Martinez, that dealt with the right to post-conviction counsel. Ironically, in the context of two defendants who had post-conviction counsel, but counsel that failed them. And what I suggest is going on in those cases is not a desire on the part of the court to find a constitutional right to post-conviction counsel. That seems highly unlikely to me in the foreseeable future. But some desire to provide a mechanism for convicted defendants, particularly those convicted at trial, to have the court hear a claim of ineffective assistance of trial counsel. Justice Kennedy wrote the opinion for the court in Martinez, and he wrote what I think is a striking statement. He said, quote, "A prisoner's inability to present a claim of trial error is of particular concern when the claim is one of ineffective assistance of counsel." And it's striking to me because that elevates ineffectiveness claims above the more typical record-based trial error claims that are raised on appeal and for which you do have a constitutional right to an attorney to raise. So if the court's concerned about your right to raise a claim of ineffective assistance of counsel, but doesn't give you a lawyer to do so, what does that mean? And I'm not sure what it means, but I think it foreshadows the possible limited expansion of the right to counsel, perhaps to something that we could call ineffectiveness counsel, like we have appellate counsel, some way to bring before the court a claim of ineffective assistance of trial counsel. And if I'm right about that, then the implications for non-capital defendants are much more significant than for capitally convicted defendants, even though much of the writing and thinking about this area is in the capital context. So let me just briefly talk about what the court did in Maples and Martinez. How many people are familiar with Corey Maples' case from last term? Corey Maples, he's an inmate on death row in Alabama. He was convicted in 1997 of capital murder and sentenced to death. And he was represented by two lawyers, one of whom had never tried a capital case before, and neither of whom had ever tried the penalty phase of a capital case. Under Alabama law at the time, this was 1997, the lawyers' compensation for their out-of-work preparation for the case was statutorily capped at $1,000 for each of them. And their in-court time was capped at $40 an hour. So if you think about these two solo practitioners who were responsible for all the overhead in their offices, no matter how much work they did preparing for their client's death penalty trial, the most they could get paid is $1,000 for their out-of-court time. Perhaps not surprisingly, given that they didn't do a very good job. They didn't raise obvious defenses. They didn't object to prosecutorial misconduct. They didn't conduct any investigation into their client's social history for the penalty phase. And Corey Maples was convicted and sentenced to death. His case was affirmed on appeal. And then he got lucky, or he thought he did, and managed somehow to get the high-powered New York law firm Sullivan and Cromwell to represent him in his state post-conviction proceedings. They filed this extensive post-conviction petition alleging ineffective assistance of trial counsel, and the petition just sat there in the trial court for a while. At some point, the two associates of the firm left the firm. They never told the client, and they never told the court. A few months after that, the trial court denied the post-conviction petition and signed an order prepared by the state to that effect. Under Alabama law, you have 42 days from that point to appeal, to file a notice of appeal to the higher court. The order was sent to the law firm, went to the mailroom. The people in the mailroom sent it back to the clerk and said those lawyers are no longer here. The clerk didn't do anything with it. 42 days came and went, and his time for filing a notice of appeal expired. The Attorney General in the case wrote a letter to Maples and said, your time for filing anything in state courts has expired. You might want to know that your deadline for filing a federal habeas is about to expire as well. Very nice of him to send the letter. And Maples called his mom. His mom called the firm. And the firm sort of frantically figuring out what happened, tried to file something in state court, an out-of-time appeal. That was denied. They filed a petition in federal court, trying to raise those same ineffective assistance of counsel claims. And the federal courts deny the claims and say, we're not going to reach the merits because they're procedurally barred, right? That we're going to respect the state court's decision that you are raising those claims as barred because you didn't comply with the rules for filing a notice of appeal. And the lower court cited Coleman versus Thompson, which is a Virginia case from the early 90s in which Roger Keith Coleman, a Virginia death row inmate, also had high-powered corporate law firm on his side, Arnold and Porter. They also missed the deadline to file a notice of appeal. And in a famous opinion by Justice O'Connor, which began, this is a case about federalism, the court said that even if Coleman had strong and effective assistance of counsel claims and he had strong innocence claims, the federal courts weren't going to review his claims because he violated the state rules. And the failure of the state post-conviction lawyers could not constitute cause to excuse that default because there's no constitutional right to counsel in post-conviction anyway. And so in Maples' case, the lower federal court cited Coleman, and they told Maples he was out of luck. And he petitioned for review in the Supreme Court, which agreed to take his case. Around the same time, the court also agreed to hear a non-capital case from Arizona. This was Martinez, which also dealt with the failure of post-conviction counsel. And like Maples, the lower courts in Martinez said, even though your post-conviction attorney screwed up, that's not grounds for cause to excuse the default. You're not constitutionally entitled to a lawyer, so even if they fail you, you're out of luck because you weren't entitled to that lawyer in the first place. So here are these two guys in front of the Supreme Court, both saying they're post-conviction attorneys to which they were not constitutionally entitled, screwed up their cases in a way that deprived the courts of the opportunity to review their claims of ineffective assistance of trial counsel. The court could have used these cases as a vehicle to announce a new constitutional right to post-conviction counsel. Or they could have used them simply to reiterate the rule of Coleman versus Thompson and deny relief. But they did neither. Both these cases were 7-2 decisions with Scalia writing a dissent that Thomas joined. In both cases, the court said, we aren't going to disturb the rule of Coleman. So you don't have a constitutional right to counsel. And in general, the failure of post-conviction counsel doesn't excuse a default in federal court. But we're going to make a limited exception in each of these cases. In Maples, we're going to say that the attorneys abandoned the client altogether. Here, he essentially had no attorney at all, so his failure to meet the filing deadline can't be attributed to him. It was something external to him, and thus can be considered cause to excuse a procedural default. In Martinez, the court said, where this is your first opportunity to raise an ineffective assistance of trial counsel claim and your lawyer fails you there, then the default can be excused in federal court. In dissent, Scalia, I think, was in rare form, and you know it's going to be a classic bitter Scalia dissent when it starts, as it did in Martinez, with the words, let me get this straight. And what Scalia says is it doesn't make any sense to reiterate the rule of Coleman that defendants are bound by the mistakes of their lawyers and there's no constitutional right to post-conviction counsel, and then to turn around and excuse the default anyway, with little, in sort of vague terms and with little regard for a precedent that will be set for future cases. And I think there's something to Scalia's point in both cases. The court really goes through contortions in both cases, Maples and Martinez, because it seems concerned that the courts are not able to review the seemingly legitimate claims of ineffective assistance of trial counsel. But because it doesn't want to go down that road of requiring, as a constitutional matter, the right to post-conviction counsel, it comes up with these equitable and procedural workarounds to allow the claims to be heard. And what I think enables this approach, as opposed to one that requires post-conviction counsel, is that in virtually all capital cases, counsel is appointed. Most states provide counsel in capital cases, or you're able to get a pro bono firm or organization to represent you. And so the court doesn't have any real concern in capital cases that counsel won't be appointed at all in post-conviction. And it can focus on what to do in those cases where post-conviction counsel is appointed but somehow screws up the case. But in non-capital cases, there's no counsel generally. So the right to post-conviction counsel in non-capital cases takes on much more significance. Let me put it another way. In capital cases where you generally do get a lawyer in post-conviction, the relevance of having a constitutional right to counsel is that it provides you with a mechanism to excuse procedural default if the post-conviction lawyer that you got appointed fails you in some way. But in non-capital cases, the relevance of having a constitutional right to a lawyer is that you get a lawyer that you wouldn't otherwise have. And the court's rulings in Martinez and Maples take care of the problem to some extent in the capital context. They enable capital defendants to have their day in court on their trial ineffectiveness claims, even if their post-conviction lawyers fail them. But the court's rulings in Martinez and Maples by themselves do very little for non-capital defendants by not requiring the appointment of post-conviction counsel and only providing a mechanism for excusing the failures of post-conviction counsel where there is post-conviction counsel. The court leaves non-capital defendants, which of course is the vast majority of defendants, out in the cold. Yet the court does seem concerned. The justices seem concerned about the right to raise a claim of ineffectiveness. As I mentioned Kennedy's statement in Martinez earlier, they seem willing to elevate it to at least the level of record-based trial error claims, or even higher. But they're going to need to grapple with what it means for the vast majority of defendants convicted in non-capital cases who have no meaningful way to vindicate their right to effective assistance of counsel. The fact that the cases have come to them in the context of defendants who have had post-conviction counsel appointed has distorted the relevance of the remedy that they're providing. So I'm out of time here, but I'm interested in exploring and would love to hear any thoughts about what mechanisms might be available to ensure that all convicted defendants have a right to their day in court on an ineffective assistance of trial counsel claim, assuming I'm right that the court isn't going anytime soon to find a sweeping constitutional right to counsel on post-conviction. And in the wake of Maples and Martinez, I think that could be the next major fight in the post-conviction litigation context. And although the procedural principles are somewhat arcane, the bedrock principle of the right to effective assistance of counsel at trial is not. And the implications are obviously quite high for the many thousands of defendants convicted of non-capital crimes each year.
Thanks.
Thank you, Ty. Our final presenter tonight is Robin Steinberg. Robin is a graduate of New York University School of Law and has been a public defender her entire career. Starting as a criminal law trial lawyer with the Legal Aid Society, continuing his career as a founding member and a deputy director of the Neighborhood Defender Services of Harlem, and ultimately creating the Bronx Defenders in 1997. She has extensive experience in every aspect of public defense, from representing individual clients to creating a nonprofit organization. Today, Robin advocates nationally and internationally for holistic representation in the community defender movement. She is a true pioneer and leader in the field, and has been honored by, among others, the National Legal Aid and Defender Association for her, quote, exceptional vision, devotion, and service in the quest for equal justice, and by the New York Bar Association for her outstanding contribution to the delivery of defense services. Please help me welcome Robin Steinberg.
Thank you. So I'm particularly grateful and honored to be here. As I am not, despite your initial introduction, a professor. I'm not an academic. I'm not going to talk a lot about cases or precedent because I wouldn't really know much about what I'm talking about, and I haven't used a footnote before doing the paper for this symposium since 1981 when I was at NYU Law School. But what I do know is public defense. I know it from the front lines. I know it from the different places that I travel. I know it from having been a public defender for 30 years and representing poor people in the state criminal justice system in New York City. And at every conference and every important anniversary date of Gideon, like the 50th, but it could have been the 10th, it could have been the 20th, it could have been the 30th, it could have been the 40th, the community of public defenders and academics sometimes wind up talking about the same thing, the underfunded nature of public defense. And it is indeed underfunded. But while we sort of rightly bemoan how much other players have in the criminal justice system, we correctly complain about the high caseloads, high turnover rates, we ponder what it would look like if we were well-funded and well-staffed and we could work in the clinical models of public defense that we all adore and many of us have been a part of and that go on in law schools across this country and that we honor. But for my part in this talk, I don't really want to fall into the paradigm of that. I don't really want to turn into we're underfunded and we can't. What I want to do instead is really to try to talk about how we should aspire really to be delivering services to our clients and to the poor people in this country who are caught up in the criminal justice system without making those compromises. And specifically to sort of think about ways that organized public defender systems and offices can fulfill the promise of providing effective assistance of counsel as promised by Gideon. That's my one cite to a case. As I was driving down actually from New York City this afternoon, I heard on NPR a speech that Governor Cuomo was giving. And he was talking about Hurricane Sandy, and as you all know, we just had a terribly devastating hurricane up north, and it had a devastating impact on New York City and on the surrounding areas. The flood was really indescribable, and the devastation was shocking, and the results are still sort of being felt from one end to the other in the tri-state area. And of course, when that happens, there's a lot of Monday morning quarterbacking that goes on, and everybody starts complaining. How come this happened? Why did that happen? Why weren't we better prepared? Why didn't we know how to do this? And I have to say that Governor Cuomo, in trying to explain on the radio this afternoon how we could have been so unprepared for the storm and the devastation that would follow and be so shocked by the damage that was done, Governor Cuomo said very simply and very directly, the infrastructure of New York City was built for a different time and a different place. That's why the subways flooded, that's why the tunnels flooded, and that's why the bridges couldn't withstand the storm. And so it is with the right to counsel. And so it is with public defense. And so it is, looking back 50 years since Gideon was first articulated. The world has dramatically changed, and with it, so has the criminal justice system. Not that long after Gideon, there was what people have decided to describe as either a spike in crime, a crime wave, an epidemic, whatever you want to call it, crime began to climb in this country, and with it came a get tough on crime mentality. And that mentality led not only to harsher and more draconian sentences and careened millions and millions of people into the prison system over the past few decades, it also led to the creation of penalties that were long hidden from the view of public defenders who were representing our clients, but were being experienced in really heartbreaking and dramatic ways by the clients that we represented in their own communities. And further, as proof of sort of the get tough on crime mentality and earning people's credentials, politicians and lawmakers and policy setters made sure that over the past few decades, through local and national legislation, administrative codes and regulations, that the punishment of people convicted of crimes would go far beyond incarceration. That the punishment for people convicted of crimes, even of minor crimes, even of those kind of quality of life minor crimes that people think we shouldn't take seriously, that the penalties would go far beyond incarceration, far beyond thinking about just the liberty interest, into the other areas of poor people's lives, into their families' lives, their children's lives, to their homes, to their livelihoods, and to every possible arena you can imagine. These punishments, which many people, I think, shouldn't but do refer to as collateral consequences, they're really not collateral. They're direct and they're dire and they're immediate. But people began to sort of, the punishments began to sort of be called collateral consequences of criminal justice involvement, and those consequences can be and are as destabilizing and as soul-crushing and as disruptive to a client's life and her family as her loss of liberty might be. Get convicted of a minor crime, get deported. Get convicted of marijuana, lose your federal financial aid. Get convicted of a violation, lose your public housing in New York City. Get convicted of a crime, your kids are going to wind up in foster care. Get convicted of a crime, never be able to come back into this country, even though you've lived here most of your life and you go to visit your grandmother in Jamaica. There are a million of those kinds of hidden penalties that go far beyond liberty and far beyond the criminal case. And as those penalties grew and expanded beyond the criminal case, and the potential loss of liberty became only one part of the punishment. And that's what was being extracted from poor people coming through the system. But there was something else going on. And this is where we really ran into trouble, as we as public defenders were way at the late end of understanding this, right? There was a technology revolution happening in this country. And how is that relevant and why does it relate? Well, poor people, who are most often people who are ensnared in the criminal justice system, and at a disproportionate level, poor people of color who are ensnared in the criminal justice system, poor people are involved in administrative agency after governmental office after governmental office. Their entire lives are bound up in and dependent on and intertwined with these governmental agencies every single day. The welfare office, the public housing authority, child welfare agency, the local school system, the local clinic, the public clinic, you name it, just to name a few. When those systems didn't have the ability to talk to each other, the sort of hidden dire penalties that were wrapped up in and created by the get tough on crime mentality that began to connect criminal justice with all these other areas of clients' lives, when those systems weren't talking to each other, sometimes we could actually hide from them and we could avoid them. And I remember when I was a young public defender, we would literally be able to say to a client who wasn't born in this country and might have immigration consequences of a criminal case, don't worry, they're never going to find you. It's a 6-month sentence. It's not going to happen. The problem is that technology has sort of brought those systems together, and they're talking to each other. They're talking to each other so rapidly and so precisely and with such incredible precision that they can connect and arrest for a poor person in the criminal justice system, in the state or federal system, in less than 24 hours. And by the time that person hits the first court appearance where bail is going to be set and a judge is finally going to be seen and a lawyer is going to be assigned and charges will be drawn up, immigration is already there, the detainer has already been lodged. There is, up on the desk in New York, judges have actually a screen by the desk when you're being arraigned that will show them whether your client's name has ever been entered in the domestic violence registry, ever been entered through ACS in the child welfare agency. These systems are talking to each other. So those penalties now actually can be found very, very, very quickly. And that means that with a minor arrest, that deep stabilization happens quickly and without mercy. At the same time all this was going on, right, policing in urban areas has been changing dramatically, right? In some ways, this is where the New York City experiment we've created this problem in large measure, and I guess we have to own it. But starting, a long time ago, 2 mayors ago, policing began to change. And what the experiment was in New York City was the sort of zero tolerance order and maintenance policing that has now been exported, and I will tell you that our police commissioner, Ray Kelly, loves to go all across the country and all across the world preaching about the New York experiment in policing. But as policing changed, right, so did the criminal justice system. And so that the overwhelming majority of people coming into the criminal justice system now, in the state system, right, are charged with crimes that are the result of order maintenance policing. In other words, they're being hauled into the system. The majority of people, overwhelming majority of people in urban areas across this country are now being hauled into the criminal justice system for minor misdemeanor offenses. There aren't complaining witnesses. There's not a lot of investigation to do oftentimes. They are minor in terms of what the possible ramifications are in terms of liberty interests, but they still remain incredibly major and destabilizing in all these other areas of a client's lives, no matter what the liberty interests might have looked like. Most clients will never go to trial. Most of these cases are pled out, they're plea bargained, but with those plea bargains come those hidden penalties, those penalties that go beyond just the liberty interest. What that means is that lawyering, as we traditionally thought about it, and certainly as I was traditionally trained to do it as a public defender in 1982 when I started, that form of lawyering that we traditionally think about is actually reduced to a very different process, and in some ways to very different skills. The fact that order maintenance policing results in more minor arrests isn't going to protect our clients from the penalties that go way beyond the criminal court penalties. And because the possibility of jail is reduced in the minor cases, the other penalties actually, oftentimes in the state system for our clients, will become of paramount concern to the client. Public defense and what it means to be an effective, high-quality public defender, quite frankly, has to change. And it particularly has to change in high-volume urban areas where order maintenance policing has become the thing of the day. And public defender offices have to figure out ways to reconfigure themselves to reflect those changes. Resources have to be allocated to reflect the real needs of clients. Resources have to be moved from one place to the other. Lawyers have to be retrained to understand the complexity, not just of the criminal case in the ways that we think about criminal cases traditionally, but also in the other penalties and other consequences that come with that. Public defender leaders have to think more about how to allocate resources more creatively and become less lawyer-centric, thinking of ways to use advocates and students and volunteers and community members and, yes, even ex-clients to provide support and services and counsel. Look, the other thing that I want to sort of mention in here is what we do is actually a very old concept. That's the interesting part about this holistic defense. It sounds revolutionary. It sounds, whatever you think it sounds. It sounds like a new thing. The truth is, right, what public defense does is poverty law. That's what public defense is. It is, at its foundation, poverty law. And if we think about it that way, everything I'm talking about in terms of holistic defense and thinking about the other consequences and combining civil and criminal representation sounds far less radical, right? If we think about the work we do as related to poverty and connected to poverty and both causing and creating poverty, the interconnectedness of those issues are easier to appreciate. We are poverty lawyers. How did criminal defense for the poor get completely separated out from other legal issues that face the poor, but that are deeply and clearly connected to criminal justice involvement? And here's what I'm going to say. Damn you, Gideon. Because the truth is, Gideon is one of the ways and one of the culprits that actually caused us, I think, to lose our way in public defense. And here's why. Gideon was an astounding, world-changing opinion, but what it also did was it inadvertently, consciously, but had inadvertent consequences. It consciously led to the creation of funding streams to provide counsel for indigent clients who needed them in the criminal context. Right? Once you have the weight of the Supreme Court decision behind you that says you must appoint counsel, you have to have a funding stream that's related to that. And so what managed to happen is poverty lawyers of old, who might have looked a little bit more like Harry's Law storefront for poor people, that would literally work on any legal matters that any poor people had from the community that walked through their doors where they needed help and they needed support and they needed counsel, those offices quickly got relegated to civil legal work, and public defender work got siloed out. It got pulled out. And look, I don't want to look a gift horse in the mouth, Gideon, because actually that's why we get funded. That's why my office gets funded, right? Because of Gideon. But the downside, actually, was to make worse what has become the siloed practice of lawyers, right? The legal silos that have created a public defender system that in some ways could deliver at its best great representation on a criminal case, but ignores the impact that that criminal case has and the interconnectedness of the other issues. And we public defenders, once we got that funding stream and once we got siloed out, we just never looked back. If you look back, and my paper talks about this, and I won't go over it because you can just sort of read it, right? If you look back at sort of, like, if you look back at it, right, there were lots of movements before anybody started talking about holistic defense or community-oriented defense or even client-centered representation that looked like poverty law, where these issues were all together, where people were in small storefront community offices that were representing people in all these different arenas with whatever problems they brought in. And so the silos of pulling criminal defense away from that, and then the ultimate silos that got created by funding mandates that would basically say, well, we'll let you represent this person, you know, on this kind of civil case, but you can't have a criminal conviction. Or if you're legal services, you can do this, but he has to be born in this country, right? And those then sort of funding streams also created worse silos. So holistic defense is actually the subject of my paper. And I think one of the great values that holistic defense adds is that it seeks really to break down those silos that have been created, right? It recognizes the interconnectedness of poverty and criminal justice, and it engages public defense with the community that it serves in broader and more impactful ways. And there's a lot of talk these days out there in the indigent defense community about client-centered lawyering and community defender offices. I don't do anything with the community defender movement. They are distinct and interesting concepts that add great value to the conversation about what public defense should look like. But there is an important distinction to draw between client-centered lawyering and community defenders, which is that client-centered lawyering and community defenders are concepts that add a lot to the conversation about how we can better meet clients' needs, how we can better interact with our clients, how we can better empower clients, right? But what they don't do is create a model that actually has elements and specific things that have to be present that may be replicable and then could be spread across the country and that will actually respond to clients' needs. Another second, I see the song. So, you know, holistic defense, we have them, and you'll look at it in the paper. Again, we've got pillars. It's a foundation that we build the model upon. And the pillars are very simple. They provide seamless access to legal and social service needs for our clients. They provide advocates that are trained with an interdisciplinary skill set to identify needs beyond the criminal case. There's ongoing dynamic and real-time communication amongst all those advocates in a team-based way, and there is meaningful and productive engagement with the client community. And models matter, and this is what I'll end on. Here's why models matter, and here's why it's important for us not to confuse the different ideas and the different concepts. Models can be tested. They can be compared. They can be replicated. We can learn from them and change them and tinker, and when we drive them by data instead of anecdote, that actually can help us learn how to deliver services in a far better way, and public defenders are notoriously bad at thinking about data. The Department of Justice funded us to travel across the country to actually teach other defender offices in all different models how to do holistic defense. And one of the things that becomes obvious the minute we start is if I sit and I ask almost any public defender office, brilliant, wonderful, dedicated, incredible people doing unbelievable work, and I say, what are the percentages of your clients who are in public housing? What percentage of your clients are not born in this country? How many of your clients have involvement with child welfare? There's a complete blank expression. And so one of the ways we're trying to move this model forward is to get public defenders to begin to collect data that actually will then inform them of who their clients are, where the areas are where criminal justice is interacting in other areas of their lives, and they have to create resources and then respond to that. And then build resources in that actually respond to that. So holistic defense winds up offering both individual representation that addresses the concerns and issues clients have in the criminal justice system. It also creates, and the final point is, real mechanisms, genuine mechanisms, for public defenders to engage in the client community, gather information necessary, and then take collective action to make change. Whether it is taking on the stop and frisk practices of New York City, or doing what we did several years ago, which was using law students to literally take every trespass case we had in our office, where a young person had been arrested for being in the park after dark, sending our students out over the course of 2 months to take photographs of every park in the Bronx, to prove when the cases came in that in fact none of those parks had signs up that said you're not allowed to be here after dark, which every police officer, everyone in every case swore in a signed complaint was present. And then you have a choice, right? What do? Well, you can go do a lawsuit, and that gets you, lots of recognition and sometimes some damages, or you can do what we did. And here's where holistic defense, I think, trickles up the information so that you can actually engage in advocacy and organizing in ways that are not just legal and not just lawsuits, which is we took a PowerPoint presentation to the DA's office in the Bronx. They are not exactly our friends. They really are not. And we sat down and we said, here's 50 trespass cases. Here are the 50 complaints signed by the police. Here is the PowerPoint of every park that exists in the Bronx. Not one of them at their entrance or their exit has a sign that says you can't be in here after dark. And I will tell you the upside of this. The upside of this is we have never seen a trespass case in a park again since that day. That's how sort of creating models that have real mechanisms where information the public defenders can gather can actually trickle up and actually do more than just individual representation, but actually fulfill the promise not just to the individual, but actually also to engaging in the larger issues of justice and fairness. It's time to rebuild New York's bridges and tunnels and subways to reflect our changing environment, and so it is to rebuild and re-envision and reassess our public defender systems because our infrastructure was built for a very different time and a very different place.
Thank you very much, Robin, and I apologize for the professor comment. You would consider it a field promotion or maybe a field demotion. Yes. I stand here with about 20 minutes to go and in a dangerous posture because I stand between everyone here from cocktail hour. What a moderator usually does is gives the questions that he or she would like answered and tries to lead the discussion. I'm just going to throw out 4 or 5 questions, and I'll let you guys decide what you would like to answer or maybe not answer if you have some other thoughts. Based on what some of the stuff that I've read here. The first question or issue I see is whether or not the problem with the ineffective assistance of counsel doctrine is tied intimately to the limits of habeas corpus relief. That so much of post-conviction litigation has to be squeezed through the eye of the needle of ineffective assistance of counsel. And that if you changed the doctrine with regards to habeas corpus, either by statute or by judicial, by case law, that some of the problems with regards to ineffective assistance of counsel with regards to that doctrine might change. A related question is the notion of incorporating in, as to some extent the doctrine requires, external standards, like the ABA's standards with regards to defense counsel. Whether that's appropriate and how that should be done, given that you are taking a body of non-law and essentially creating it or turning it into some law, and whether that has what role that has. Another issue is the problem with ineffective assistance of counsel is all of the litigation involves 20/20 hindsight, and the impossibility of reconstructing what happened at the time, and how much of this becomes shaping whether or considering whether a particular move was a matter of strategy or was a constitutional blunder. And it's just it's a problem with the notion of appellate review trying to second guess the decisions of trial counsel. And in that you might have the various biases and heuristics, including the one that ties in with what I just said, the notion of hindsight bias. Third issue is the problem of overcriminalization, and this was touched on a little bit by Don in his presentation. And by that I mean the propagation of more and more crimes, excessive punishments, overloading the system, usually through this type of political one-way ratchet that the late Professor Stuntz so eloquently discussed in his work. And I just, in terms of the number of folks behind bars, I just think this is a great visual. 2.3 million people behind bars now in 2008, meaning that 1 out of every 100 Americans are incarcerated. And to put it in perspective, if you placed a prison wall around North Dakota, South Dakota, and Wyoming, and counted every single person as an inmate, it would still not equal the nation's total prison and jail population. The population would get a little bit closer if you included in American Samoa, Guam, and the U.S. Virgin Islands as penal colonies. A final question that, again, you can choose to address any of these if you wish, is what do we do? And this was, Ty mentioned litigation and the possibility of, that some of it we've seen with individual defendants. More likely we saw, or perhaps more successfully, we saw in Michigan an attempt to sue the state to require it to pony up with regards to defense counsel. The national report, the report of the National Commission on the National Commission on the Right to Counsel, the Rational Right to Counsel Commission, the report, they said we need to create a state board or commission responsible for indigent defense services, establishment of qualification performance, workload standards for defense counsel, prompt determination of eligibility and assignments of counsel for indigent defendants, collection of data on cases involving indigent representation, adoption of open file discovery policies in prosecutor offices, which Professor Mosteller has been a leading scholar and proponent of, and the obligation of defense counsel to refuse excessive caseloads and other things. And one thing I'd just like to throw out, and then we'll leave it up to you, is I wonder whether or not we are taking this, all of these things are simply trying to put duct tape on a machine that's broken. And I think Robin discussed this eloquently in her discussion, but I wonder whether or not it is a part and parcel of the problem that we have in a hyper-adversarial American system. That the problems that we have with regards to ineffective assistance of counsel don't exist in other countries, in perfectly civil countries that use forks and spoons. That the issues that we have seem to be unique to our system of legalism, and in particular the hyper-adversarial system of criminal justice that we have produced. So with that, any of those questions are of interest, or if you have any other thoughts, please feel free.
Let me say a word about habeas as the gateway to all this. 15 years ago, I wrote an article that said you can't do this after the fact. You've got to do it ex ante, before the trial. You've got to establish the effectiveness of the sentence for all kinds of reasons. But leave aside the doctrinal problem about when you can raise ineffective assistance. Let's assume that the first time you can raise ineffective assistance effectively is at state post-conviction. And if that's true, then it doesn't do any good to the 90% of the people who plead out. And then it doesn't do any good to anybody who's not in long enough to get to the state post-conviction process. And you're probably going to lose in the state court because they know there isn't any money there, and you're going to have to go over to the federal court. And in California, it takes you 6 years to get from trial conviction to collateral attack in the federal district court and an order from the magistrate that's going to be signed by the judge. So you have to be in for 6 years before. Well, what kind of cases are those? Right? Well, there are a lot of capital cases, right? And then some other people who look like they've done some pretty darn bad things. And that has a way of warping the law in these cases. You don't get a lot of attractive cases. Right? So that's why I'm excited about LaFleur and Fry, because that suggests an inquiry into counsel's performance in the plea process, which is those 90% of the cases. And you could do that ex ante in a very, very simple way. Just say the court will not enter a plea unless the colloquy establishes a checklist of things that every competent lawyer has to do in a criminal case.
Yeah, I think the habeas is obsessed with bring forth the body, or the custody over the body. Right? We have this obsession with individual people, like individual defendants matter in some way. But a case-by-case system where you're looking at a particular case and judging ineffectiveness years later when so many of the problems that we're all talking about are systemic issues and issues of best practices, or a case-by-case system isn't going to necessarily be a good system to get at those underlying issues. I did have one, with a duct tape comment, one reaction to Robin's talk, which was sort of along these lines. I'd be interested in what Robin says, which it is kind of depressing if you think about our country, where we have to think about poverty work being done so much by lawyers, and in particular having leaders in poverty law being criminal lawyers. Right? That is sad, right? Maybe you would very much want a different kind of person to be leading community efforts to do poverty. But that's where we are.
Let me a follow-up question on in terms of changes or possibilities, and I mentioned a few of them. Michael Tonry, a very well-known criminal justice scholar, has suggested that we need to move to a civil servant model along the lines of what Europe uses. George Thomas, also a well-respected scholar, suggested that we should have something known as criminal justice professionals. And the idea there would be that, somewhat similar to the system that was used in England until about a couple of decades ago, those individuals who represented the prosecution or the defense, they wouldn't necessarily know beforehand. You had a group of barristers who would end up representing their clients. Sometimes they'd represent the Crown, sometimes they'd represent defendants. And that would solve some of the problems with this battle between the defense and the prosecution, and also this problem with regards to funding, where the prosecutors end up getting the lion's share of funding, and it's always pulling teeth to get the defense bar funding.
That used to be the military system. In the military system, you had to defend before they let you prosecute. And it does change your perspective a little bit. The military went away from that, and you can see the kind of political hurdle that any kind of integration of that function would have to get over. The prosecutors are self-selected because they're politically ambitious and they have a punitive orientation.
Yeah, I was going to say that the very politics of sort of defense versus prosecution in this country would make that a really tough model to do. I mean, I personally think that the jobs are profoundly different jobs. I think they require different skills. I think they require different sensibilities. I think they require different levels of humanity. That's my personal view. Switching back and forth, I'm always stunned when somebody who's a prosecutor becomes a defense lawyer, and it almost never happens the other way. And I think there's a reason for that that go much deeper than just sort of the seeming skill sets of being a criminal lawyer.
I want to ask you, Eric, why do you think in a system that has 95% guilty pleas it's too adversarial?
I don't know. It sounds like one party may have a big hammer and the other may not.
Why does it matter whether you could have people switching roles all the time, but in a plea bargaining system?
Well, I'm on the focus, I guess. As a moderator, I don't have to justify any of my decisions. Let me ask Ty a quick question. I know you work a lot on capital cases in California. What is your perspective with regards? In California has, I don't know whether to call it a famous or infamous system with regards to the death penalty. Lots of people on death row, very few executed, although they trickle through. And lots of ineffective assistance of counsel claims. Do you think that the doctrine as applied there is successful, has failed? What would be your suggestions given California's unique position, being somewhat of a leader in putting people on death row, but unlike Texas, not a net executor state?
Yeah, well, California's death penalty system is completely dysfunctional. And kind of alluded to. We have the largest death row in the country by far, twice as many as Texas, the next largest state. But we rarely execute people. We haven't executed anyone now for 6 years. We've been held up with lethal injection litigation. And as some of you know, on Tuesday, there's a ballot initiative that would have abolished the death penalty in California that failed relatively narrowly. It was
47%.
Yeah, 47%. Which, when it was first proposed, I think a lot of people in the defense community thought it was crazy and that there was no chance that it would ever become close to passing it. and yet it did. And I think part of the rhetoric, or the campaign rhetoric, was all about the cost of the death penalty in California, particularly given the payout. You know, if you're more likely to die on death row in California of old age or of suicide than from being executed. And so even people who are in favor of the death penalty in California weren't getting anything for all the hundreds of millions of dollars that it was costing. And I think that's partly because the California Supreme Court, which administers everything related to the death penalty in California, has relatively high standards for the appointment of post-conviction counsel, which is required by California law. And what the state is realizing is that it's incredibly expensive to provide good lawyers for people. And I think this goes to one of your earlier questions about over-criminalization. So that's been true in the capital context. That's been true in a lot of states that have tried to provide counsel. You know, New York had, when it had the death penalty, it had a very well-funded capital defender office that was so successful in keeping people off death row, but its budget was slashed every year. And the same thing happened in Georgia. Georgia recently had a capital defender office statewide. It was sort of the model, but it was so good that it cost so much money that it also is getting its funding slashed. And I think what will eventually lead, to me, would eventually lead to a reduction in over-criminalization. Not necessarily in the capital context. Capital crimes are always going to be prosecuted. But really, when we're talking about the run-of-the-mill criminal cases, the real problem is over-incarceration, over-criminalization. And I think the only thing that's going to really reduce that politically is the expense of doing it right. And you know, that's, I think, can explain to some extent the Washington and Colorado's legalization of marijuana, where, you know, again, people are seeing how expensive it is to prosecute people for low crimes that then have these incredible consequences. But that's not what grips people morally. It's you know, why are you paying for these prosecutions? So I'm not so worried about the doctrine. I don't really have a problem with the Strickland standard. I just think if the court is pushed to expand it, and people realize how expensive it is to actually provide post-conviction counsel, for example, in a run-of-the-mill criminal case, that's going to lead to a real, are we going to spend all this money to hire more lawyers, but where can we cut out the expenses at the front end of the criminal litigation?
Right. To tie that with some other points that were made, in the death penalty context, so much of the litigation depends on the charging decision. And Brandon appropriately mentioned that in 95, and depending on the crime, vacillates the percentage of cases that are actually result in being plea bargained. But most of the debate with some of these capital crimes is not over guilt, it's whether or not the death penalty is going to be on the table. And in terms of the adversarial nature, the argument would be something along these lines. That the incentive to charge and to charge high is so great, simply to use as leverage, so that a the defendant or defense counsel simply have no choice but to take that deal. And you compare that to Ron Wright's in the audience, and we'll be presenting tomorrow. He did a really fascinating study with Mark Miller, comparing it to what New Orleans did, at least under Harry Connick Jr., or Sr. The Jr. is the singer. Senior, where they were required to do this really hard look at the files and kind of almost a truth in charging doctrine, and to not engage in the type of where most of the action occurs behind closed doors between a prosecutor and defense attorney. With assistance of counsel and the recent cases that have dealt with, this last term dealt with plea bargaining, how much of the right to counsel really is squeezed behind closed doors into the question of bargaining and the discretion of the prosecutor, and as compared to what we see, kind of the tip of the iceberg, with regards to the assistance of counsel that occurs at trial.
By themselves, standing the way they are, LaFleur and Fry are no big deal, because what they are is the right to withdraw the plea and stand trial, right? Which is not in the best interest of the client. The client does not want to stand trial. because of the trial penalty. So that remedy, right, for the problem of systemic bad defense work is not helpful. Right? That just puts the defendant back in the position where he's facing a coerced forced choice, and it's in his interest to say yes to the deal, whatever the deal is. So that remedy is not very well calculated to enforce the right that's declared to effective representation in the plea bargaining process. The only remedy that's going to work there, and I'll come back to this, you don't enter the plea unless you see on the record that there's been effective representation.
Let's see if the audience, we have about 5 minutes left, see if the audience has any questions that they have for. Please, Mr. Bowers.
I just have a question for Robin. Hi, Robin.
It's cheating, Josh.
So, I was just struck, obviously, by your statement, damn you, Gideon. So I wanted to sort of...
It was for impact.
No, I understand. It was impactful. No, I just wanted to sort of try a thought experiment with you of like kind of uber Gideon. Imagine Gideon didn't come down the way it did, where it focused on appointed counsel for the indigent, therefore focusing on poverty, but instead was a decision that outlined the kind of like public education model, where everyone gets free counsel if they want to avail themselves of it. And possibly if they, otherwise they could go the private school route and they could hire counsel. Or you could imagine almost a quasi-socialist model where you'd say there are no private attorneys, no private defense attorneys. Instead, just like complaining witnesses in society, interests are represented by a public prosecutor. Everyone is represented by a public defender across the board. In that sense, the focus, it seems to me that it would not be as clearly the consequence that you'd end up with poverty law being taken away from poverty attorneys. Do you think that kind of Gideon would have been a better Gideon? I mean, for you it would be great.
I'm more curious here what you'd have to say about it, because you probably think about this now. I mean, I have long thought that counsel should be assigned to every single human being that comes into a courthouse in this country and is charged with a crime by government. And they can, as you said, opt out. Now, very rich people will probably opt out. But yes, I think that the system would probably be healthier if everybody had the sense that it could be them, it could be their brother, it could be their sister, it could be people who look like them, and that you didn't actually create sort of two entire separate worlds. Yeah.
We need Obamacare, right, for public defense. Right?
It's wrong.
Let's work on that.
Yeah, but you know what, that's going to happen now because of the election on Tuesday. We didn't hear criminal law or criminal justice come up during the election at all, right? But that's because there's a secret plan in place that's going to get sprung in just a few days. And so we're about to have cocktail hour, but there's a secret plot afoot, I think, and it's coming from Virginia, right? Because it was Webb who wanted the National Criminal Justice Commission, and that was going to be his signature thing. And he was so depressed that the Senate couldn't even get a vote on it that he left office. But the one thing, since Charlottesville is such a small town, you can meet people who are running for Senate. It's only 20 people there. So I asked Tim Kaine. The one thing I was really happy about with Webb was that he wanted the National Criminal Justice Commission that would propose national criminal justice reform legislation. Wasn't that a great idea of his? That was a signature thing. Are you going to keep doing it if you're elected? I said, oh yes, definitely. That was great. So out of Virginia, we're going to get a national criminal justice commission. It'll probably happen, in a few months. And then they're going to propose Uber Gideon, just like Josh wants. And so everything's going to be solved within, 5 to 6 months. And so we can solve it.
Hi, Abby Smith. So Robin Steinberg thinks that lawyers and other advocates are especially important in misdemeanor cases, which are frankly the bulk of the cases in the criminal justice system, because there are significant consequences beyond the prospect of jail. Donald Dripps thinks, on the other hand, and proposes, as one of his kind of pragmatic proposals, rationing the scarce resources in the system by eliminating the right to counsel in non-prison cases. I'm wondering what you each think of each other's points of view, and then I have a question for Ty about whether what you think about the idea of an IAC counsel, an ineffective assistive counsel kind of person, inventory control person, of some coming in to look at either effectiveness of counsel at trial or post-conviction, and especially in the post-conviction context, which capital defenders are not talking about, and what you do when the client says, to the one lawyer that may really have spent time and worked hard with the client would have to conflict out then as a result of somebody else coming in.
I guess yours. I thought Professor Dritz had really interesting and productive things to say. I admit that when you said that, I wanted to throw something at you. Partly because I don't think the issue of jail is the only issue by any means. And I ask this, to myself all the time in my personal life. I'm like, if I was given the choice between spending some time in jail or giving up my kids, what would I do? What choice would you make? What sane system makes people make those choices? But those are indeed the way those penalties play out. So I would say that I don't think that even summons cases really should be going on without counsel, unless we were, if the legislature decided to decouple all the penalties and we were to roll that all back, then, I'd be left looking for a new profession, probably, right? Because at the end of the day, that would be a huge victory, and people could focus on representation on a criminal case the way that we were trained to think about doing representation on a criminal case about governmental authority and liberty, instead of all these other enmeshed penalties that are so deep. And so, the solution to that would be to roll back the legislation, and then I'd be happy to adopt the professor's suggestion about that.
In my defense, let me say that proposal is clumsy. You look at the cases that these misdemeanor cases, they're being brought by police testimony, they're very hard to defend. Why is that? Well, the system moved away from anything that requires a witness because a real trial by a good lawyer makes it difficult to convict even if you have any kind of squishy testimony. So these cop testimony cases, DUI cases, buy and bust cases, stolen and possession cases, they all get priority because they're cookie-cutter cases and anybody can win that case. And what happened? What get pressed out? Rape cases, kitty cases, and domestic violence cases get pushed out because if there's a good lawyer there and a Crawford right to confrontation, the cross-examination raises reasonable doubts and prosecutors don't like losing. So my thought on this is, right, why not reverse that feedback and say, let's create an area where the procedures are simpler, where the penalties are smaller. Right now in the state cases, 40% of the felony convictions don't carry an immediate sentence of incarceration. And if you didn't have to appoint lawyers and risk that expense and the risk of losing the trial, you might see that figure go to 60%. And if it went to 60%, that would be a huge difference in terms of our hyper-incarceration problem. And I think I like that world better even with the collateral consequences that I admit are very serious concerns.
So I like that idea of ineffectiveness counsel. I mean, so in Douglas, the Supreme Court said you're entitled to appellate counsel, right? Because we care about your ability to have someone who looks through the trial record and raises claims on direct appeal. Now the court is saying, we think trial error that's related to ineffective assistance of counsel is just as much a concern, if not more concern, than trial error that you can see in the record. So I like the idea of saying, okay, in addition to appellate counsel or it's the same person, you get an ineffectiveness counsel whose job it is to review not the trial record, but the whole case, including what the trial lawyer didn't do. That would be a huge expansion of what's constitutionally required now. But it would enable you to see whether, the lawyer did the investigation he needed to do, primarily around investigation, and then do it and present what wasn't done. I'm not so worried unless I misunderstood your question. If we can talk about it with drinks. What the conflict would be. I mean, you already usually have a different appellate lawyer, so this would be another lawyer that would come in and talk to you about.
I mean, there's a sort of move for ineffective assistance of counsel kind of look at the post-conviction lawyers work, especially in capital cases. And I think that's really complicated because sometimes the client wants to hang on to that lawyer even though they may not have been perfect.
Yeah, right. So that's at the second level. There's someone just wrote a paper about the ethical implications of that. I think that gets really complicated.
This has been a very fascinating panel, and obviously the beginning of what looks to be an outstanding symposium. You would please help me thank Brandon Garrett, Don Drift, Ty Alper, and Robin Steinberg.